Court.
Good morning, everybody. Thank you very much. Please be seated. Before we call the case, welcome students. Milton High School, love to see you. Thanks for coming. We'll have a Q&A later this morning. Yeah, okay, good. All right, so please go ahead, call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Dousevicz, Incorporated CU and Site Plan Approval. Case number 24 AP 130. Representing the appellant, Kathleen Culpo et al. Is Bridget Remington, and representing the appellee, Dousevicz Incorporated, is Christopher Roy.
Thanks very much, counsel. Please come on up. If you would, for the record, introduce yourself, identify your client, and then go ahead.
Thank you, Chief Justice. Good morning, Your Honors. I'm Bridget Remington. I'm representing appellants, a group of concerned residents from the town of Castleton, Vermont. At issue today is the town of Castleton's Development Review Board's decision to approve a 22,500 square foot, 4-story, 99-unit senior living facility along Sand Hill Road in Castleton, Vermont. Sand Hill Road is a rural side road with primarily 1 to 2-story single-family households.
Ms. Remington, doesn't the ordinance, however, sanction the this type of use? It's a PUD, and it's approved for a PUD.
The town, 3 months after signing a purchase and sale agreement with the developer, amended its zoning ordinance in February 2021 to include planned unit developments as section 417 as allowed uses under the ordinance in the rural residential zone 2A, which is where Sand Hill Road is located.
And the town sold the property to the applicant, correct?
Well, they haven't sold it yet. They just have a purchase and sale agreement. It's a conditional purchase and sale agreement, which depends on them being able to obtain the necessary permits and licenses. So right now, the town still owns the property. The important thing to know about the facility is that it doesn't look like a residential building. It looks like a commercial or industrial building, and it's essentially a carbon copy of a facility that the developer recently built in Berlin, Vermont. It's located next to the Berlin Mall complex and the Walmart, really close to UVM's Central Vermont Medical Center. So first in this case.
So Ms. Remington, I apologize for interrupting you again. You did not file a statement of questions. You did not file a timely appeal. So as I see it procedurally, the only party who appealed here is the applicant. And the town didn't appeal the DRB as well.
The only appeal into the environmental division was made by the developer. They sought to remove some of the conditions that were included in the decision to approve the conditional use of the project. The statement of questions was submitted, and then my clients at the time were pro se. They each filed in pro se as individuals. But the developer chose to submit a broad statement of questions, chose to broadly ask.
Well, I don't know if those statements of questions, in my view, are broad. I think it was very narrow down to use.
I think question 4, we argue, is broad. It discusses the project's design and use. It asks whether the project is deemed an allowed use under the planned unit development, and then specifically cites to not only section 417, which is the planned unit development section, which was newly added, but it also cites to section 204G, which is all applicable regulations under applicable regulations, and Article 4, basically the entire conditional use regulatory scheme comes in, much as this court decided in Atwood. Once the developer in a statement of questions asks whether the project is an allowable planned use development as a conditional use, it opens the door to the entire conditional use regulatory scheme. So my clients did not file a cross appeal, nor did they need to. The developer.
You did cross appeal though, didn't you, on question 5?
Not a cross appeal. I filed once they saw that the developer chose to submit a broad question. They assumed they would be able to discuss conditional uses, and they should be able to. The developer also chose to submit the February 2021 amended zoning ordinance, which specifically does not allow a height waiver under section 417. So when they saw that on the motion for summary judgment, the undisputed material facts exhibits included that ordinance, that version of the ordinance, they immediately sought legal representation because they knew they would need assistance. And so at that time, when I looked at the evidence submitted, it was clear that a cross motion for summary judgment should be submitted on the height issue, because to be able to qualify as a conditional use, the project needs to be able to meet the restrictions that are in Article 5, which is the table that includes the 38-foot height restriction in the rural residential zone where the project is meant to be located. So I filed a cross motion. The developer then filed a reply seeking to, filed a motion to strike the cross motion, which eventually was granted. I requested the ability to file a surreply or to have a status conference, because the issue of which zone is applied could have been an issue. The court chose to make a decision that it was outside its, the environmental division chose to make a decision that the height issue was outside of its jurisdiction.
Could I change gears with you a little bit here? Move to the DRB's decision and its application, its exception of the memory care unit from its approval. It held in the decision that it applies the ordinance, the town ordinance that requires cooking in each of the units in order to qualify as a multifamily dwelling, and concludes the memory care unit proposed does not qualify as a multifamily residential use for that reason, because of the cooking, and because there would be no kitchen facilities in the units that are dedicated to memory care patients, which is understandable. However, as I read it, the appellee argues in its brief that the board applied this rationale inconsistently, and that therefore it is not something that we should respect. What's your position about that?
I don't think we found any evidence of an inconsistent application. The only facilities that the definition of multifamily residence specifically predetermines are within that definition are sororities and fraternities. In Castleton, there are no sororities and fraternities. So there could have been no inconsistent per se application. I think as it pertains to other instances that were brought up at the merits hearing to show that there was an inconsistency.
So is it your position that there was not an application of this provision in the ordinance that inconsistently by the DRB?
Nothing specifically was presented, whether or not in the history of this definition being included in the zoning ordinance, there has been inconsistency. I would not know because it wasn't part of the evidentiary record.
If there was inconsistent application, would you agree that that the law would not support, it would in fact support the environmental court's conclusion here?
It depends. I mean, I think if they were consistently inconsistent, potentially, but other than that, I can't think of, it would be a completely factual analysis.
Okay.
I think what my understanding of the environmental division's decision is that the division actually relied on a 50% majority analysis, which I see as quite tenuous. I think it was trying to get to a substantial compliance type of decision, but here, usually, it's my understanding that this court would find substantial compliance would require more than a pure 50-50, which is the case here. About 50% have kitchens, 50% do not. I'd like to reserve
Actually,
a
let me
minute
ask
and
you,
a half for rebuttal.
I'm sorry. Before you reserve your rebuttal time, there is a question that I'd like to ask you now. And that is question 5. Neither party briefed question 5 as to whether or not the ordinance is in violation of the Fair Housing Act. Should question 5 inform this court in its analysis?
I don't actually know the question to that. I don't know the answer to that question. I think I chose not to brief it because it didn't seem that there was much to argue. I mean, it's either just if this board chose to take it up, I think the evidence is on the face of what's available to you, but I don't want to brief it. But
If it is remanded, then what happens to question 5 in your mind? If this court
that
remands?
issue, I assume we would need to gather more evidence. And no one testified, there was no evidence presented on that issue. As to the height, I just want to go back to reiterate what the court has said, that this court has said, that the environmental division could have and should have considered questions that were intrinsic to the statement of questions, included within its scope, issues that were intrinsic to the statement of questions. The court's jurisdiction is not limited to the literally stated text, and the broad question asked in question 4 did open the door. I just wanted to reiterate that there is no height waiver, so currently the approved project is not in compliance with the controlling document, and there was no need for a cross appeal. The decision on motions specifically stated that the regulatory provisions cited directly did not address any dimensional standards, including height, that may be applicable to the project. That is a crucial point here. I think if you look at the entire conditional use regulatory scheme, the zoning ordinance as amended certainly does address dimensional standards, setbacks with lot coverage. That all does involve dimensionality. So because the statement of question explicitly references the PUD section of the zoning ordinance, requires consideration of the larger scheme, encompasses Articles 2, which establishes zoning districts, 3, 4, and 5, which actually sets the restriction. The height issue is within the environmental division's jurisdictional scope, and the non-conforming height disqualifies it as a PUD. And as such, it does not meet the requirements for a conditional use permit under the amendment. And I ask that the court reverse. I'd like to reserve the rest of my time.
Okay. We'll hear from counsel for the appellee, please.
Your Honor.
And if you would introduce yourself and identify.
Absolutely. My name is Chris Roy and I represent the appellee in this matter, Dousevicz, Inc. And this is a case that presents the following question to the court. It's whether older Vermonters who no longer wish to live independently are treated as diseased patients requiring institutional care under our zoning laws, or whether, as Judge Durkin recognized, they deserve to have a broad spectrum of residential options like all Vermonters. The project here was approved under a PUD provision that allows for multiple family dwelling units and not nursing homes. And out of that, three key issues have arisen. First of all, to address the jurisdictional issue that Justice Waples discussed. There's no doubt that the Environmental Division is a court of limited jurisdiction. Its jurisdiction is defined by the statement of questions and those issues that are intrinsic in it. There's no question that there was not a cross appeal filed by the neighbors. And reviewing the statement of questions that was filed makes it clear that explicitly each and every one of the questions relates solely to use. And as we know, traditional Euclidean zoning, you have use requirements and you have dimensional requirements. There is exclusively a reference to use in each of the four questions, other than the Fair Housing Act question. There's no reference to dimensional requirements. And the fact that a broad ordinance was cited that relates to all of these issues, that another aspect of that ordinance also includes dimensional requirements, doesn't create jurisdiction when none of those dimensional requirements are mentioned in the statement of questions. And before I get into the PUD piece, I do quickly want to address the question that Justice Waples had about the Fair Housing Act. It wasn't addressed below because there was a favorable decision by the court, and so therefore it became moot. I do think, however, it's appropriate to keep in mind that a decision about senior housing that runs afoul of the discrimination standard in the Fair Housing Act does potentially create liability for the municipality. And the reason that's relevant here and goes to whether the facility or portions of it should be considered a nursing home versus a residence is very simple. All of us may have friends, relatives, parents who have lived in single family residences and who may have the assistance of visiting nurses come from time to help them with personal care, maybe cooking, taking care of the house, just checking up on them, maybe taking their blood pressure, seeing if, oh, something's not right, we should call the doctor. People have that in their homes, be it a single family home, be it an apartment in an apartment house. That level of limited monitoring, medical oversight, and personal care doesn't render each of those residences into a nursing home. It's their home. And this building is basically an apartment building.
Can you address the claimed ambiguity here that led the Environmental Division to adopt its own definition?
Well, yes. And so you have the definition of nursing home in Article 9 of the ordinance. And the term that the court below deemed ambiguous was in-house nursing care. And as you can imagine, in-house nursing care could, in theory, be one nurse shows up once to you're hooked up to machines and are being monitored constantly by professional nursing staff. Where on that spectrum is this ordinance intended to draw that line? And in order to guide what level of in-house nursing care would render private residence where nurses come and help a resident into an institutional nursing home, the Judge Durkin appropriately looked to the state regulatory and statutory system for nursing homes to provide additional detail regarding what you look to determine whether something is or is not a nursing home. And as we've pointed out, the facility that's being operated in Berlin, Vermont, which is virtually identical to this facility, is not regulated as a nursing home. It's regulated as an assisted living facility. And the key is that you don't have what's used in the statute 33 VSA section 71027, skilled nursing care.
How can that apply though? How does a regulatory statute trump the town's ordinances, which don't require skilled nursing care? They require nursing care for it to be a nursing home. I just don't understand why the court took or made reference to a statute that is in effect for a whole separate reason.
Well, and I think it's because the court determined, as I discussed briefly, the concept of in-house nursing care is not sufficiently clear to determine where along that spectrum of care. If it literally is a nurse shows up once, then you're going to have every person in Castleton, whoever has a visiting nurse stop by, file a change of use application as a nursing home.
But these nurses, there were nurses there on site though. This is a little different than the VNA coming twice a week to see if you're doing okay.
Well, they're not residential nurses. They're not there overnight. There is nursing staff available, just like at a school or other places, as needed, and they do, again, their rounds. But again, similar to how VNA would do it. You have a schedule and you stop in and you check in on people. They do not provide skilled levels of nursing. But what they do is they identify this person now needs a level of care that we don't provide, and therefore work with the family to move them to that.
Well, the ordinance has other aspects of the definition that would sort of get you out of the residential issue, I think, doesn't it? It's got 3 or 4 different prongs to it, to make it a nursing home.
Right. Well, I think that the best analogy, and frankly, the ordinance itself does this. It uses explicitly the example of group homes as a multifamily residential building. And then if you look at the definition of group homes that the ordinance provides, it says that you can have over 8 people, all in their separate rooms. They can live as a single housekeeping unit. They can be provided room, board, and supervision. They can be provided other services at the group home that meets their needs, including explicitly their health needs. So embedded within the definition of multiple family dwelling units is a use that is very similar to what's going on here. And furthermore, I mean, you can, this gets into, angels on the head of a pin in law school, but I mean, you can also get to the point where this is 18 units out of 99 units. To the extent something more is being provided in a memory care unit, or something more is being provided in the assisted living unit, that's an accessory use. It's not, the primary use is that of a multiple family dwelling unit. And the accessory uses are uses incidental, subordinate, and reasonably necessary to the conduct of the principal use and located on the same lot as the principal use. And again, that's consistent with how the ordinance itself deals with group homes. It has, the group home is in its heart a residential building, and we will regulate it as a residential building. But we recognize that accessory uses and activities will take place, including room, board, supervision, and health services. This is very, very similar. I mean, you could get down in the weeds and say that you have an accessory use of a group home within the memory care unit within the larger building, and so on. But ultimately, what is intended here is there has to be something other than a bright line between living independently and being treated as a patient in an institutional care facility. That's how the care and living situations of seniors have evolved over time. As a society, we've realized there has to be something in between. There has to be a spectrum of residential options that are available to people, as opposed to before, is what you lived at home, probably lived at home too long until they had to put you in a nursing home, and then you're hooked up to the tubes, and that's the end of it. As a society, we've moved past that, and this is the very type of facility that is designed to respond to that spectrum of needs, and the law has to be flexible enough to address it. And this court has emphasized on numerous occasions that when there is ambiguity in an ordinance, that it should be construed in favor of the landowner and the free use of land.
Does the court, is it proper for the court to make those policy decisions? Or are those policy decisions made by the town when passing their ordinances? It seems here that the court had policy in mind that necessarily wasn't the same as what the town had in its ordinances.
Well, I think there's no dispute that 50 of the 99 units are residential apartments. No question, there hasn't been any dispute about that. So right off the bat, over 50% of the units are residential. Then you get into the assisted living. Assisted living has a kitchen, but instead of a stovetop and oven, it has a microwave. And then they have depending upon the individual, somebody will check in on them every day. And then you have memory care, some of whom are otherwise very healthy people. They just have dementia and need to have a level of monitoring and security and supervision that's different. Ultimately, the facility is a residential facility under the terms of the ordinance. And you have some units within that move along the spectrum that are far short of an institutional hospital type facility that nursing homes, and it's going to create a mess if you have facilities like this that are desperately needed in the state, having to navigate a state regulatory system. And this court did look in the Vermont Permanency Initiative to how the state defines group homes in construing zoning. Is if you have a state overlay of this is a nursing home, this isn't a nursing home, and then zoning comes in and is crossing paths with that, you're creating a situation where we are not allowing our communities to be able to deal flexibly with the shifting needs of folks. The goal here is to allow an individual, let's say, obviously, if they don't like the place, they can go somewhere else. But let's say they like it. They start off in independent housing. As they get older, they need a little bit more help, then they will move to assisted living. If, God forbid, they suffer from dementia, they'll be comfortable knowing that that's available there. And then when the time comes that they need sort of skilled nursing care and chronic care, then they'll move to that appropriate facility that's going to be licensed and regulated as a nursing home. And that's the sort of use that the ordinance is intended to address. One thing I would like to mention about the cooking facilities and whether, again, you could never have a memory care unit apparently in Castleton because you don't put cooktops and ovens in with dementia patients. The goal there is to distinguish a multiple family dwelling unit from something like a hostel or a motel where you go elsewhere to eat, because that creates more impacts. That means you're going in and out for your meals, and you're more of a transitory nature. And whereas if dining is provided for on site, that is more of a residential situation. And so again, getting hyper technical about the language here is losing the forest for the trees as to what the policy was that was intended to be advanced, which is we want to distinguish multiple family dwelling units where people are living on site from more transitory residential situations like hostels, motels, and other things.
But the town of Castleton picked the language.
Yes, and that's why they've used, and again, and this is true, the court interprets ordinances just as it does statutes, and you strive to find an internally consistent way to interpret it that is reasonable under the circumstances. And there is a very, as Judge Durkin demonstrated, I mean, there is a very easy way to go through the interpretation of these ordinances that realizes that this sort of facility is allowed under the ordinance. and therefore is something that this court ought to affirm with respect to the decision that Judge Durkin made below.
Mr. Chief Justice, may I ask?
Yeah, please.
Mr. Roy,
Yeah.
another question? Thank you. Mr. Roy, I want to follow up on Chief Justice Reiber's question to Ms. Remington as to how much deference does this court give the DRB in their application of the ordinance?
This is not, there has been no demonstration of these particular provisions being applied one way or the other over time by the DRB. We have the DRB's one-off interpretation, and I don't think that that's the sort of situation that this court has spoken to in the past, where a DRB over time has consistently applied language in a very specific way, and therefore, because of that, basically the landowners are on notice that this is how we interpret it going forward. This is a one-off interpretation, so I don't think it's entitled to the deference that you're referencing.
Okay.
So the first time never gets any deference.
The first time the DRB interprets it doesn't get any deference, just like now the environmental judge doesn't get deference, used to be, and that rule has changed as well. It's a matter of law and essentially statutory interpretation for this court.
Thanks very much.
Thank you.
Time is up. How much time does the appellant have, please?
Appellant has 1 minute and 33 seconds remaining.
Okay, counsel?
The developer framed the issue as whether the residents of a facility deserve certain levels of care. That is not the issue that's before the court today. The issue today is whether a proposed facility comports with a zoning ordinance that a town adopted and amended recently.
Council, can I just jump in for a second? The DRB interpretation,
Yes.
I think I understand your point to be that it's not ambiguous. They provide nursing care and meet the other definitions, that's that. Why didn't the DRB also say the assisted living section was also a nursing home? Because it looks to me on the record like they have a similar level of nursing care being provided.
They didn't speak to why one over the other necessarily, except to say that the memory care unit was different. The people who are going to be residing in memory care will be locked in. They will require additional supervision. It isn't, as the developer characterized, that this is an apartment building where everyone will be living freely. That is not the case. The memory care unit is a locked unit. If, as the developer now proposes, which it has changed over time, as you can see from the record, that this is an assisted living facility, then every unit would have its own cooking capacity as required under state statute. I think the environmental division should have given deference to the DRB interpreting its own definitions and regulatory scheme. And the environmental division had a plain and unambiguous definition, which could have been clarified easily by looking to the nursing care definition in Vermont statute. The facility will provide in-home nursing care. It is not an accessory use to have memory care there. Accessory uses are cited in the statute as things like garages, sheds, tennis courts. Not the type and use, as the developer noted, is in every question he asked, whether the use of the facility is an allowed use under the planned unit development. And importantly, there are memory care facilities in Castleton. The developer stated that there are not, but there are residential care homes with memory care. They just comply with the zoning ordinance. And we would ask that the court reverse the environmental division's decision and ensure that this facility also comports with the zoning ordinance placed in the town.
Okay, thank you. Your time has expired. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.